the 2017 accountability law, which included new authorities it requested to better hold its employees accountable. Tracy, can you tell me what's changed and why the VA now concludes it doesn't need additional authorities to discipline mid-lower level employees from those outlined in Title V?
So, Senator, within the last 6 years, we have seen the challenges that implementing 714 faces. In the entire bill, we are using the provisions that deal with 713, which allows us to take actions against senior executives, and we are also implementing the provisions of the bill that allow us to recoup bonuses and awards, as well as relocation expenses and reduce annuities. So there are many provisions of the 2017 Accountability Act that we are using, and the fact that we have the OAWP established as a venue for employees to air their concerns and grievances and have those investigated. I think what we have seen with the legal challenges in the courts, as well as with the labor partners, is an opportunity to strengthen our processes and procedures, not just on the back end when it comes to proposing and deciding an action, but the need for that increased consistency and improvement in our policies and procedures, as well as our reporting and collecting of data on the front end. And that's why the LEAD Act fits so much better into what we need to do to make our the department more accountable in the future. So I think what we have seen is where we need to strengthen our employee relations procedures so that we can hold employees accountable, and that is on the execution of our authorities as opposed to additional authorities.
Mr. Robinson, can you talk about the department's position on what would happen if Congress gave you broader disciplinary authorities with lower evidence standards and fewer due process protections?
Yes, thank you for the question, Senator. You know, it obviously, the details of what types of due process protections are being lowered and what other changes are being proposed matter in that type of conversation. But generally, you know, what we will see if, you know, additional authorities that do those things are provided, you know, we will, as Ms. Therrett mentioned, we will see legal challenges, and we will go through that litigation process with really no guarantee of the VA will prevail in those legal challenges. You know, we have spent the last 6 years in administrative and judicial courts talking about these burden of proof and due process issues. And, you know, if we're talking more specifically about provisions such as those in the Restore Accountability Act, you know, we do have, the department has legal concerns, significant legal concerns about how those would play out in court. And I would also like to emphasize what Tracy had mentioned, which is, you know, accountability starts long before we get to the point where we're proposing actions. And so what we like about the LEAD Act is being able to focus our attention on that front end process where we're focusing on trying to make investigations more efficient, more thorough, and devoting our resources to that.
After the 2017 law was passed, VA took several steps during implementation, and those steps landed them in court. Mr. Robinson, why did the VA end up winning most of those cases, or did the VA end up winning most of those cases?
So with respect to implementation, there's kind of two lines of cases that we talk about. And the first line of cases is in the labor arena, where we you know, implemented the decision was made in 2017 to implement and start using the authority without bargaining prior to implementation with the union. A grievance was filed at that time, and from there it culminated in the AFGE settlement agreement that we've discussed. And in between then, there was a lot of litigation between those 2 points and a lot of events that occurred during that time. And then the second line of cases really had to do not so much with implementation, but had to do with interpretation of the statute. So really, when we're talking about just implementation that occurred in 2017, we're talking about those labor cases.
And those court decisions ended up in a situation where a number of employees had to be reinstated. Is that correct?
Well, there were certain, when we're talking about the labor cases, there was, one case related to performance-based actions in which performance-based actions were overturned and folks were reinstated. As far as the other labor case that resulted in the AFGE settlement agreement, a smaller number than the pool of individuals impacted by that decision will be reinstated. And, there's a whole process that is going to have to play out in facilitating that settlement agreement.
Senator Cassidy.